Welcome to today's program titled Multi-State Handbook Updates for 2023 and Beyond, What to Look Out For and Why It Matters. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down as it will not be reread and is required for CLE credit. Copies of the webinar, recording, and materials, along with the CLE attendance form, will be distributed to attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. At this time, I would like to turn it over to our first speaker for today's program, Chelsea Mesa. Chelsea, please go ahead.
Thanks so much, and thank you everybody for joining us. We're really excited that you're all here. It is one of our favorite topics to talk about, handbooks. You know, happy Thursday, happy handbook season. You may not know there is a handbook season, but now that we have gotten the legislative sessions all closed, we've had an opportunity to digest what is new and notable and what you'll need to know, what to do for your handbook for 2023, so we can get all of our handbook updates done. So today, just so you know, I'm Chelsea Mesa. I'm a partner in our Los Angeles office. I am also the leader of our national handbook and policy team, and I'm joined today by three of my very esteemed colleagues on the team: Meg Toth from Chicago, Jean Wilson from Boston, and Renata Walker from Atlanta. And so the four of us today are going to walk you through a lot of really fabulous information about handbooks, why we love them, why you should love them too, and some of the things to look out for 2023. But I do want to go over an agenda with you. We do have a lot to cover, but on the next slide, we can talk about what that's going to be. After we conclude our introduction, instead of waiting till the very end like we did last year, if you were with us, we held the developments till the very end. We thought we would give these right out of the gate. It was a lot more active this last year in general employment law. We're finally starting to focus away from COVID when it comes to policies. And so we thought it would be nicer to start with our state developments right out of the gate. CLE is still offered at the very end, so you'll have to stick around, but the major developments we'll get right out of the way at the beginning. We'll also remind you, for those of you who may not even have handbooks or maybe don't think handbooks are all that important, why it's so important to have a good handbook, and of course, state addenda that address kind of the differences among the states. We'll go through some best practices in developing your handbook, talk about some trends in the law and what you should expect going forward, 2023, 2024, and beyond. And then we'll give you a little bit of what we've been working on, you know, how our handbook and policy team has been helping employers over the last couple of years since we developed it, and what we can do for you, of course, more specifically. So no wasting time here. Diving onto the next slide, into our 2023 state developments. The developments we're talking about are ones that will impact your handbook and your policies. And what better place to start than our good friend California? As I mentioned, a very busy year. California has always been notable as being very employee friendly, had taken a little bit of a hiatus when it came to major developments in the handbook world, but last year we saw a lot come through the legislative session that will impact your handbook, and you'll need to be aware of some of these things. So on our next slide, we'll talk about the first one of these, which, you know, not to start with a downer, is mandatory bereavement leave. And this is a law that essentially applies to almost all employers in California. It's going to require that employers provide their employees with up to 5 days of bereavement leave following the death of a family member, as long as that employee has been with you for at least 30 days. They define family member. They borrow the definition from how CFRA was written at that time, although there is some dispute as to whether the new CFRA definition, which we'll talk about in a minute, applies here too. I think that's still a little gray. The leave must be concluded within 3 months of the date of the death of the family member. It doesn't have to be consecutive, and it can run concurrent with a current paid benefit if you have one. But this is an unpaid benefit. There's no requirement that bereavement pay, although you have to provide it. It doesn't have to be paid. Employees obviously can use vacation, personal, etc., that's otherwise available to them, including sick leave. And we are allowed to ask for documentation. So good to know, but definitely something that if we've got a bereavement leave policy policy, we want to amend it to include this. And if we don't have a bereavement leave policy, this is something that's going to be new for you, and we'll want to make sure that it's in your handbook going forward starting January 1st. The next detail I just mentioned, I teased a little bit, was that CFRA and paid sick leave in California have both been amended to add in the definition of who's a covered family member this concept of a designated person. And you might have been aware of the designated person. Some of the Northern California ordinances already included it, although you'll see the definition in CFRA and in the state paid sick leave law are a little different. For CFRA, they defined it as any individual related by blood or whose association with the employee is the equivalent of a family relationship. And that's how Los Angeles defined one of its covered family members up until, I think that's where they got this idea for this definition. But at the end of the day, this really could be anybody that they designate. And in the paid sick leave law, it's much broader. It really is any individual designated by the employee. Now, the employee has to designate the person at the time they're taking the leave, and we have the ability under both laws to limit that employee to one designated person per 12-month period. So if I'm going out on my leave and I designate my dog walker that I want to take care of, I'm not going to be able to a couple months later designate my second cousin for leave for the same purpose if I've already taken it. So very important to note that both of these policies will need a little bit of a tweak for 2023 and going forward to incorporate this new covered family member. On the next slide, I want to address some of the other brand new laws for 2022 that you may not have noticed. If you have employees working in West Hollywood, hopefully you are already aware, because this one went into effect as of July, just a couple of months ago, that West Hollywood has a compensated time off policy. And it is different than a paid sick leave law because it essentially provides for time off for any purpose, including sick. The guidance from the city that we have received is that they do not intend for it to apply to exempt employees, but that is something that we wish they had given us a little bit more concrete guidance on that. That's what the city has told us. And the accrual rate for this law is 96 hours, essentially a year, so 96 over 52 per week, and it can be prorated for part-time employees. There is that annual accrual cap of 96 and a point-in-time accrual cap of double that, 192 hours. So it is a much more generous law than what you see from a general sick time law. And as you know, in California, there isn't a law that mandates the provision of vacation, but this is the first time we've seen that outside of the hotel space. We know that there's some ordinances like that and government contractor type ordinances that address that. But for general private employers, this is the first time we're really seeing that outside of the hotel space. There's also an uncompensated time off measure when essentially somebody runs out of their compensated time off. They're allowed to be provided this accrual of uncompensated time, 80 hours over 52 per week. That annual accrual is 80 hours as well. On the next slide, I wanted to give a little bit more detail on this one. We have received additional regulations on this, that employers can combine their various buckets of vacation and sick time that they're providing together, so long as it results in more, no less than 96 hours per year. So very important to note that. And the previous iteration of the law that went into effect originally had included a monthly cash out if the employee's balance reached that 192. That was part, if you know the LA hotel workers ordinance that you will remember that is something that is required. When somebody hits that cap, they have to be paid whatever they would have earned in addition to the cap every 30 days. West Hollywood got rid of that, so we don't have to worry about that. So that's great. And so you do have options under this law. You can give a bucket of paid time off, or you can give buckets that are some paid time off, some vacation and some sick, and still be compliant. But we do have to also remember that the sick time laws, the vacation laws do still apply. So the way that you're providing your West Hollywood time off needs to comply with sick time and vacation as well. The last thing I wanted to talk about for purposes of California developments was San Francisco's public health emergency leave, which essentially took what they had been doing for purposes of COVID, made it a little bit more general. We know that there are a couple of other jurisdictions that have done this. Instead of having something that's specific to COVID, they're adopting a law that provides for paid time off when an individual is dealing with a set of circumstances because of a public health emergency. And this applies to employers, larger employers with 100 or more employees worldwide, essentially as long as you've got somebody working in San Francisco Francisco, the person in San Francisco is going to be covered by this law. There isn't a tenure or hours requirement, and it does have the ability to be waived under a CBA, but essentially how it works is there needs to be a provision of 80 hours a year for purposes of public health emergencies, and it is dealt with in the same way as regular sick time, same pay requirements, same pay stub requirements as it is under paid sick. And the reasons for use are covered on the next slide. Essentially, when there is a public health emergency at issue, if you've been told that you should be isolating or quarantining, or you have symptoms, or you're caring for a family member, or there's a school closure, all of the things that you would have recalled from the previous COVID style of sick time laws, but adds this air quality emergency. We know that's an issue that we deal with up in San Francisco quite a bit. So we have another covered reason for use in San Francisco that essentially allows, when there is an air quality emergency for someone with particular health conditions, to be able to use it in that way as well. And so with that, I will go ahead and pass the torch to Jean, who's going to talk about some of our other developments around the country.
Thanks, Chelsea. So we're going to move over to the other coast and talk about some changes in New England. And there are basically some small changes this year. You can go to the next slide. The first state we're going to talk about is Connecticut. As you likely know, there were big updates last year with the introduction of the Connecticut Paid Family and Medical Leave Act and the amendments to the Family and Medical Leave Act. What's new as of July 1st is that employers are now required to provide notice of these laws, and that notice has to be provided at hire and then annually. So one way you can satisfy that obligation is to include a compliant policy in your handbook and then provide the policy annually. Or you can provide the template notice that the DOL created, and there is a link to that that you'll get when we forward you the deck. So no real new obligations except for the notice. One comment about the content of the notice: it is generally what you would expect and what we include in a leave policy, but employers are specifically required to include a statement that an employee has a right to file a complaint with the Connecticut DOL. So I just wanted to point that out because that's not something we would typically include in a policy. The next change was to Connecticut's Human Rights and Opportunities Act. That act had applied if you had 3 or more employees. It now applies to all employers who have 1 Connecticut employee. So essentially anyone who has an employee in Connecticut. And they have also added status as a victim of domestic violence as a protected class. And then that brings us to the final Connecticut topic, which in that same legislation, the legislature included a provision that employers must reasonably accommodate victims of domestic violence by providing reasonable leave of absence for reasons related to domestic violence. And there's no indication of how long that might be. That the word reasonable is just used. And one thing to note is that this leave is in addition to family violence leave, which is also provided for under Connecticut law. And that family violence leave law provides 12 days of leave for reasons related to family violence, which is defined slightly differently than domestic violence. Unfortunately, we haven't gotten any guidance as to how these obligations interact with one another, but employers should assume that if employees take off more than that employees can take off more than 12 days if their leave is covered by that domestic violence leave law. So if they fall into that definition. And then also, just as a quick reminder, the 12 days of family violence leave can be also covered by the paid family and medical leave law. So employees can get benefits for 12 days of that type of leave. We can go on to the next state, which is Maine, I believe. And so as you can see here, effective January 1, Maine has joined the states like Massachusetts that require payout of vacation time upon termination. And the law is going to apply to all employers with 10 or more employees. It's not clear whether that is going to be 10 Maine employees or 10 overall. The statute doesn't require just Maine. So for now, we're assuming it's broader. And so this is another one where you may know that a few years ago, Maine passed an earned paid leave law that provides up to 40 hours of earned paid leave. And like Chelsea was talking about, that time can be used for both sick time and vacation reasons, similar to one of the new California laws. And that law specifically says that if an employer says in their EPL policy or doesn't say anything at all, they don't have to pay out earned paid leave when somebody leaves. And so those two obligations potentially conflict. You have to pay out vacation, but you don't necessarily have to pay out earned paid leave. Initial guidance from the Maine DOL is that if you maintain a separate vacation policy and an earned paid leave policy, that you don't have to pay out the earned paid leave, but you do have to pay out the vacation. I think we'll be getting some more guidance on that as time goes on. And then in Maine, also the Equal Employment Opportunity and Anti-Discrimination Law was amended. They amended the definition of race to include traits associated with race, including hair texture, afro hairstyles, and protective hairstyles. These are often referred to as the Crown Act, and we're seeing this a lot across the nation, that these characteristics are being called out specifically. And then I'm going to wrap up with the next slide on Vermont. And the only change in Vermont is that they've amended their crime victim leave. And these amendments go back to May 24th. They're not big changes, but they have expanded the definition of who is a crime victim to be defined as an alleged victim of a crime or delinquent act. And employees are now entitled to take leave if their family member is an alleged victim and meets one of the criteria listed there: is a minor, has been found to be incompetent, was killed as a result of the crime, or was hurt physically or emotionally. So you just want to look at your policy and ensure that the updated language is included there. And luckily, we have no Mass, New Hampshire, or Rhode Island changes. So I'm going to hand it over to Meg for the next group of states.
Great. Thank you so much, Jean. I am going to be talking about some other updates from New York to the Midwest and a little bit beyond. I think we're having a hard time sort of tying all of my states together, but we did an okay job, I think. So starting off with New York, and why I said New York and a little bit beyond is because the main change in New York was related to its paid family and medical leave law, and it was the addition of sibling to the definition of covered family member. So on that topic, we also wanted to put in a plug for the state of Washington, Oregon, and Colorado, who all also have paid family and medical leave updates, which if you were able to tune into our webinar earlier this week, or you're interested in watching the recording, we actually did a whole series on those laws. So I was just going to briefly put in a plug for those changes. And the changes include, for Washington, adding additional time off for bereavement, addressing time off for a postnatal leave period, clarifying the waiting period, and some other changes as well. And then Oregon and Colorado are important to note because those laws, which have actually been enacted for quite some time now, are starting to go into effect. Specifically in Oregon, contributions for employers begin, or employers and employees begin January 1st of 2023, so just around the corner. And then the benefits are going to be available in September of 2023 for employees. And then Colorado, similarly, contributions are set to begin in January, and then benefits will be available the next January 2024. So that is all for those states. Now moving to the Midwest, which there's not a lot in the Midwest generally, except for in these two states, there are quite a bit. So starting off with Illinois, there was previously a law in Illinois called the Child Bereavement Leave Act, and that was amended to go into effect January 1st of 2023, and it is now called the Family Bereavement Leave Act. And it has the same FMLA eligibility and coverage requirements as it did previously, meaning this law applies to you if you're an FMLA covered employer, and employees are eligible for it if they are eligible for the FMLA. How the law has changed includes expanding the reasons for use, which not only includes traditional types of bereavement leave for the death of various family members, but it also includes time off for miscarriages, for stillbirths, for failed adoptions, as well as other negative developments related to fertility. So it's really important to pay attention to those reasons for use because they go beyond what you would traditionally think about for bereavement leave. And in addition, the law, as the name now sort of provides, has gone beyond just providing time off for the death of a child. It provides time off for the death of basically immediate family members, and it is still a 10-day unpaid bereavement leave entitlement. The next development, which also goes into effect on January 1st of 2023, is an amendment to Illinois' One-Day Rest in 7 Act, or as I like to call it, ODERISA. And this includes pretty significant changes. Right now, as the law stands, employees in Illinois are entitled to one 20-minute meal break for every 7.5 hours worked. Under the amended law, there is now an additional meal break that's provided after 4.5 hours. So at a 12-hour shift, 7.5 hours plus 4.5 hours, the employee gets another 20-minute meal break, and then an additional 20 minutes every 4.5 hours worked thereafter. If employees are in fact working 16.5-hour plus shifts, that's when that would come into effect. Additionally, the law, as it currently stands, provided a 24-hour rest period in any 7 calendar day period, and the law was amended to say that employees are required to get 24 hours of rest in any 7 consecutive day periods. So the scheduling needs to be looked at a little bit more closely to make sure that you're complying with that law. And there are a number of exceptions and coverage, like what employees are actually entitled to coverage under this law, which are important to pay attention to. So next on the list here for Chicago, employers who have a facility in Chicago or have a business license in Chicago are now required to comply with the new sexual harassment law, which includes policy requirements as well as training requirements. There's 1 hour of general training, 1 hour of bystander training, and that's for all employees. And then any supervisors in Chicago have to also attend 1 hour of supervisor training. Finally, I won't spend a lot of time on this, but Illinois also has enacted a Crown Act, just like the one that Jean was talking about in Maine. So that's important to pay attention to. And then finally, last but not least, it's important to note that there was some recent litigation around Michigan's paid sick leave law, which resulted in a potential significant change. That litigation is pending an appeal right now, and depending on how that comes out, which we're paying very close attention to, in February of 2023, there could be significant potential changes to Michigan's paid sick leave law. So I'm not going to go into too much detail on that right now, but just wanted to put a plug in for those people out there with employees in Michigan should be keeping an eye out for that as well. So with that, I am going to turn it over to Renata to wrap up the updates for the last few states we have.
Thank you, Meg. So I just wanted to call everyone's attention to a few additional state-specific developments. This is not going to be an all-inclusive list, but just some key developments of note. So starting out with Alabama, there's been a change to the law impacting possession of firearms at work. This will begin January 1st of 2023. All individuals will be able to carry concealed firearms without a permit in Alabama. That's separate from, an employer-related policy. But the way this impacts employers is that employers will be prohibited from restricting employees from transporting and storing lawfully possessed firearms in privately owned vehicles, subject to some specific conditions. In the interest of time, I won't go through every single detail about those conditions, but most notably for employer policies, employers will no longer be able to require that employees have a concealed carry permit in order to transport or store lawfully possessed firearms in their privately owned vehicles in their parking lots. So this is a good time for employers to review any policies that address weapons at work to ensure compliance. Moving on to Tennessee. Tennessee enacted a couple of important laws during 2022. Effective July 1st, Tennessee joined a growing number of states, including Maine and Illinois, as Jean and Meg have mentioned previously, to enact a Crown Act that prohibits employer policies that place restrictions on employees' hairstyles related to ethnic groups, with a couple of exceptions for safety-related reasons. So this is a good time to review dress and grooming policies just to make sure that they do not run afoul of the new requirements. Also, earlier this year, Tennessee enacted a law requiring employers to provide Veterans Day as an unpaid holiday for veterans. Moving on to New Mexico and Minnesota, we've had a couple of developments on the paid sick leave front in these locations. New Mexico has a relatively new paid sick leave law that went into effect in July of this year. And Bloomington, Minnesota has enacted a new paid sick leave law that will take effect in July of next year. Notably, the Bloomington paid sick leave law requires that any employer that provides an employee handbook to its employees must include in that handbook a notice of employee rights and remedies. So employers should take some time to review their handbooks and ensure that they have accounted for all of the nuances of any applicable paid sick leave laws. With that, I will pass the mic back to Chelsea to discuss the importance of an excellent employee handbook.
All right, and I know that was a lot of information, so thank you, ladies, for sharing some of our most recent developments. As was mentioned, not intended to be completely all-inclusive, but we tried to hit the ones that were definitely the most impactful for policies that y'all will be seeing as we dive into 2023. A lot happened, so we're hopeful that you will take a look at your handbooks. I get this question all the time, you know, do I need a handbook? It sounds like a lot. And so we like to talk about why it's a good idea to have a handbook and why it's a good idea to have an excellent handbook, because there's clearly a difference between something that you download off the internet or borrow from a friend and issue as your own, and one that is really truly developed for you, for your business. The difference is night and day. The impact is night and day. Your ability to use it for all of its various purposes will return to you times 1,000. And so we are definitely huge proponents, not just because it's a lot of what we spend our time doing, but we have seen the impact of what having a good handbook can do versus having one that doesn't do a whole lot. And what do we do with a good handbook? You know, they are used to establish these very uniform expectations, so our employees come in the door understanding what it is that we want from them, and also getting an acknowledgement from them of understanding of these expectations from our employees. It's very difficult for us to hold our employees accountable if we did not communicate our expectations to them. I say all the time that I'm not allowed to get mad at my husband for not giving me flowers if I didn't tell him he was supposed to give me flowers. If you don't communicate the expectation to your employees, how are you going to then hold them accountable for not bringing you the flowers or doing whatever it is that you want of your employees? So a handbook is the best way, the easiest way to be able to accomplish that right out of the gate as they walk in the door. And it also lets you show off a little bit. You can show what it is that you're offering to employees, what your benefits are, and be something that they really can rely on. That consistency and uniform expectation is something that I think a lot of employers kind of take for granted. And then when you present all of this to employees, it's much easier for them to see that this is how all of us in this same group or this category will be treated, and it really helps them understand why a decision is made, so they don't have to run to you and ask, why are you doing this, every time you make an employment related decision. It also takes a lot of the rogue supervisor out of the equation. If we've got some very clear expectations and very clear guidance on how we want decisions to be made, it really will reduce that excessive supervisory discretion, which we know a lot of the discretion can lead to claims of pretext or other types of claims. And so we want to be really clear about what our supervisors are supposed to be doing, and laying out what our expectations are in the handbook can be a good place to do that. It also, of course, is a good place to deliver our notices of any legal rights and obligations. At will employment, for example, we get to communicate that a few hundred times within our handbook so that there's no misconception about who is an at will employee within your organization. And it allows us in our acknowledgement, for example, to be our exhibit A of an employee's understanding that they are at will employees. It also allows us to be compliant with these laws that require us to have written policies. Many of the policies that in California, it's a very heavy state when it comes to legally required policy language. The best way to demonstrate that we distributed these policies is through the handbook. We can prove it right there. We've got a signature on the acknowledgement. Here's what we did and when we did it. And so that's really good to be able to demonstrate that we were abiding by the law, just bare bones. And of course, we want to communicate that we're not establishing any sort of contractual obligations with our employees in our handbook. That's not the point of it. It does become just this very reliable guidepost that our employees can use, that we can use, that puts everybody on the same page for purposes of what to expect in our employment. On the next slide, I'll continue talking just a little bit about why we need written policies. I get this question all the time too, and there are a few reasons why that is. I touched on the first one a moment ago. There are several laws that actually say if you have a handbook, this needs to be in it. That's the very, very baseline of a handbook. If I wrote a handbook that only had the legally required policies in it, that would be a very sad little handbook, and it wouldn't do what we need it to do, right? There are lots of recommended best practices that we want our handbook policies to address. An example of that would be like a meal and rest break policy in California, which is an incredibly crucial thing to lay out and explain to our employees. There's no law in the meal and rest break laws that says it has to be in writing in our handbook, but we obviously would never recommend a handbook that didn't have a California meal and rest break policy in it. Or if you're changing practices, if you've done something one way for a really long time and now you're developing a different way of doing it, a handbook is a great way, and a written policy is a great way to communicate that to your employees and then include that in your handbook, that here is something that we're going to be doing differently from now on, or confirming a practice that we've got, but we never bothered to put it in writing and now it's being questioned. Great opportunity to put that in writing and develop it so that everybody can understand what it is that we've meant by the practice that we were already doing. And of course, the last bullet point, maybe something went wrong or we were running into a consistent problem. Something really does present itself as an opportunity to do something about it. If we're trying to correct something, writing a policy on it, issuing that policy is a great way to do that. On our next slide, we can talk just a little bit about what you should be thinking about before you start drafting a policy. If you're going to do it yourself, figure out why you're doing it, figure out the purpose of your policy. It might be a combination of what we just talked about a moment ago. And then you'll need to dive into just a little light reading, the law, all of the regulations, all of the FAQs, all of the legislative history, all of the potential NLRB memos, any opinion letters on the subject of the enforcement guide, and case law. Obviously, you could just call us and ask us and we'll do it for you. But this is what we do when we are drafting these policies. And of course, you can consider whether to start with some sort of a template or whether there is something that's very unique about your business, your need for this policy that makes it come from a place that is truly unique and is going to not sound like something that's in anybody else's handbook, which is also fine too. And then on this next slide, things that we want to make sure that we're including in this, in our good policies, are eligibility, essentially who needs to care about this particular policy, what the rights are, so essentially what's in it for me, as well as any limitations, if we're putting any waiting period before the benefit kicks in, or is there an effective date where this policy is going to start in a couple of months, if we're talking about a leave entitlement, something like reasons for use. And then of course, any responsibilities of an employee, what do they have to do to get the entitlement? What are the consequences if they don't do what we expect them to do? Any resources, who do I want to talk to if I don't understand this or I've got questions on it? And if it's a really complicated topic, throwing out some examples of what is going to happen in that particular circumstance. That's a good way to explain a policy that might be a little bit more complicated to an employee. And with that, I will kick it over to Jean, who's going to talk a little bit about handbook and policy best practices.
Thanks, Chelsea. Yeah, so we're going to just dive right into this and look at some of the things that, when you start to draft or are reviewing a handbook that you want to keep in mind. And I think the first bullet here is really the most important, and that's that you are talking in clear and understandable language. You want to try to avoid legalese. And, one thing I often say to HR or managers that I'm working with is if you are having difficulty understanding what the policy is saying, you should assume that your employees are going to as well. So, if you find, if we find that somebody's asking us questions over and over again about a particular policy, we're going to revise that language so that it is really clear and there aren't any ambiguities. In the beginning too, you want to think about your workforce and consider whether you need handbooks in other languages, and there are services that can help you do that. And then even though we're sort of talking about what to do at the beginning, you want to think through how you're going to update the handbook without creating a new edition, because we all know that these are living, breathing documents, or at least that's what they should be. And so you want to find a way to update them without having to every time, give somebody the full handbook. And so what we've really seen is a real movement towards keeping your handbook online. And that makes sense for a lot of employers. There certainly are some employers where their employee population either doesn't use a computer regularly or doesn't have access. And those are the employers that, should probably still continue, at least for some segment of their population, to give out hard copies. But the advantage of considering doing it online is that it makes making changes very easy, and you can make changes just to specific policies. And then finally, the last thing is that less is more when it comes to handbooks. You want to have what's important to you, but you don't need to include everything. And particularly if you're finding that there are policies that are more really procedures, exactly how your timekeeping system works, or really detailed expense and reimbursement. We really recommend that those kinds of procedural documents be kept outside of the handbook. And sort of the same thing for like a business code of ethics or code of conduct, that be in a separate document. And so we can go to the next slide. And so Chelsea already touched on this, is that when creating a handbook, you really want to customize it so that it fits your culture and your organization. There really is no one size fits all. There are a certain group of policies that we typically recommend, but then you really want to think about your own workforce and what works for them. And you can imagine that a handbook for a professional services company may look different than one for a manufacturing company or a retail client. The next thing is think about your handbook as a resource, right? So we know that there are lots of questions that come up every day about leave policies, about pay, about vacation. And you really want your handbook to be a resource, something that people really feel like your managers, your human resources folks, your employees can go to and get information. And one of the ways to build on that is in your handbook to tailor to include who are the go-to people in your organization if you need more information on this subject. One thing we'd recommend is that you tend to use titles and not people's names, so that you're not consistently having to update when people move to a different organization. And then finally, and this is probably the biggest uptick that we've seen, is that do you need addenda for multiple states or jurisdictions? Post-COVID, we have just the number of employers that are now in multiple states has really exploded. And not only in multiple states, but in states where they've never had a presence before, nor did they anticipate having a presence. And now with the remote workforce, we're finding that they're in a lot of different states. And then on the other side of that, what we've also seen is an explosion in state and municipal laws, particularly in the sick time and leave space. And so it becomes kind of increasingly difficult to just have one national policy. And so our recommendation is the best way to deal with that is through state addenda. And most employers will try to, craft a national handbook, and then where there are exceptions, that is dealt with state by state in the addenda. Next slide. Talking a little bit about organization, and Chelsea again touched on this. The one thing is that the most important policies should go at the very front. These are the policies that we see most of the litigation around, and that again is going to be your at-will, your EEO, harassment, discrimination, and retaliation. And then you can think about things that are important to your organization that you might want to have up front as well. And the benefit is the closer they are to the front, the more likely employees are actually going to be to read it. And the harder in litigation it is for them to argue that they didn't know about it or understand it. The next slide is just a list of the sections of the handbook. This is typically how we break out a handbook. I'm not going to go through these, and we will be sending the deck out, so you'll have this when you receive the deck from us. But this is just one of the ways that you can divide a handbook up. And then I'd like to talk just a little bit about some mistakes that we see, and they're listed here, and I'm not going to go into all of them. Certainly, having really strong at-will language is one of the things that really is most important in a handbook. I would like to touch on progressive discipline. It can wind up being a really tricky thing in litigation, because if in a handbook you are promising a particular progressive discipline, we're going to give a verbal warning, then a written warning, then a final written warning, and in a particular situation you chose not to do that, it leaves you having to explain that. So we really recommend that you look at a more flexible policy when it comes to progressive discipline. And then again, I'm just going to emphasize the last point, and that is, you want to make sure that you have a handbook that is complete and addresses state law and municipal ordinances and other multi-jurisdictional issues. And then the next slide, we're going to talk about implementation. So, once you have the handbook complete and everybody is rejoicing, you want to ensure that it is rolled out in a way that gives you the biggest bang for your buck, right? So you've put all this time and effort in. Now we want to make sure that people get it and that they read it. We recommend that you do a written notice, and that, if possible, consider meeting with employees to cover relevant changes and to highlight existing policies that are important to you. It's also a time where, if you have an annual requirement to give out your sexual harassment policy, you can look and make sure that those policies are included and highlighted. You want to make sure that every employee knows how to access the handbook, particularly if you're not giving out a hard copy, so that they understand where it is and that it's easily findable on your intranet or other electronic system. And then again, if you do have a bilingual workforce, you want to make sure that folks who need the handbook in a different language have access to that. And then again, just touching on, you want to keep in mind always that implementation is unfortunately not a one and done. You're going to have a method for updating your handbook because of changes in the law, or because the company changes its policies, or because now you've hired a remote worker in Arizona, or sometimes once you get to a certain head count, you trigger an obligation, and so then you might need to include a policy because now you have 50 employees in a particular jurisdiction where you didn't before. And again, an electronic handbook allows for these mid-cycle changes a little easier. And then finally, the last thing is that, and as it says here, is even the best handbook is going to fall short if you can't prove that an employee got it. In litigation, it's the first thing. We want to have a policy and we want to show that the employee got it. So you want to just make sure you have a good acknowledgement, and that can either be electronic or on paper. And we just recommend that you keep a hold of that. Even if you issue a new handbook and get a new acknowledgement, that you keep the acknowledgements in an employee's personnel file during the course of their employment. And I'm now going to turn it over to Meg for her to talk about some trends that we're seeing in handbooks.
Perfect. Thanks so much, Jean. So next up, we're going to talk about some trends that we're seeing or that we have been seeing over the last couple of years, and sort of what to expect going forward. So what drives trends? A number of things can drive trends. A change in administration. As you all, I'm sure, know, labor and employment issues are highly dependent on our administration and can quickly change. Social and political issues impact the types of policies that we're seeing from employers in the handbook or elsewhere. Also, as we've already talked about, clearly changes in the law impact policies. And also how we work, and this is particularly relevant over the last couple of years due to the effects of the pandemic. How we work certainly drives trends in policies and changes in handbooks that we've seen over the last several years. So turning to our first topic on the next slide, one of the big trends that we have seen over the last couple of years and for some time now, and we continue to project will be front and center for many employers, is diversity, equity, inclusion, and belonging. There's certainly been an increased focus in this area, as I'm sure you have all seen. This is not only just for compliance with the law, but it also is driven by the fact that employees want to work for an organization that shares their values, and there's an increased emphasis by employees valuing this, some level of diversity, equity, inclusion, and belonging, and knowing that's important to their employers. And as a result, employers are doing a lot of things, but one of those is developing policies that show that they value diversity, equity, inclusion, and belonging. And that includes in a handbook. We are seeing more clients asking to include some sort of statement in the handbook that reflects their commitment to diversity, equity, inclusion, and belonging. Our recommendation, and certainly there's a lot of other things going on in this space as well, but as it relates to handbook policies, is if you are considering including something in the handbook around your commitment to diversity, equity, inclusion, and belonging, we recommend keeping it brief. Again, actions probably speak a lot louder than words, and of course it is important to maybe say something in the handbook, but keeping it brief is important. And it's also important to make sure that your actions are matching up with your words if you're going to include something in the handbook. Whatever you put in the handbook, we need to make sure is also being carried out in action as well. And the other thing I think that sometimes goes missed a lot of the times is employers will include a statement on their commitment to diversity, equity, inclusion, and belonging in their handbook, but then they will still have other policies that sort of subtly don't match with that commitment. For example, not using gender neutral language, not sort of adopting a dress code that reflects their commitment to diversity and all types of genders and the way people dress, and then not having strong discrimination, harassment, accommodation policies. So if you're going to be including something in the handbook about diversity, equity, inclusion, and belonging, it's also important to make sure that your policies throughout the handbook are consistent with that commitment. Okay, on the next slide, where and how we work and policies around that has certainly become a huge topic, and we're seeing more and more policies on this throughout employee handbooks. It's, I think, pretty much undeniable that remote work in some capacity is here to stay. So, employers are recognizing that, some quicker than others or some more slowly than others, but I think a lot of employers are adopting some sort of policy, which we highly recommend, that sets forth their position on remote work or hybrid work. It's really important that employers who already had policies like this review and revise them as well to sort of reflect the new, if they're assuming there's a new practice or expectations around hybrid or remote work. And then it also is important to review other policies that may be impacted by remote work and make sure, your work hours reflect the fact that you are allowing employees to work remotely and what your expectations are around that. It's important to address timekeeping policies and expectations around how time must be kept while employees are working remotely, including a specific emphasis on not working off the clock, because that could be a big issue when the employees aren't in the workplace, especially for non-exempt employees. Other policies that need to be looked at are meal periods and rest breaks, as well as reimbursement of expenses, to make sure that those are consistent with your policy on remote work and are built out enough to address those issues that may come up with remote work that didn't come up before when everybody was working in the office. Okay, on the next slide, again, a little bit more about hybrid and remote work policies. It's very important, as I said before, to set clear expectations. So we wanted to talk a little bit about what we typically see as the major components of these policies. This usually includes a clarification on how much time needs to be spent on site versus remotely. Are there set days? Can employees pick their own days? It's very important to be not only clear in those expectations, but decide from the outset how strictly enforced are those expectations going to be, and make sure employees understand that as well. It's important to identify if there's going to be core hours that you require people to be available, whether that be in the office or remotely. It's also very important to be clear in your expectations around responsiveness and modes of communication. Are you just using email? Are you going to be making sure people are the appropriate color on their Slack or Teams? Like, are you checking their red, green, and yellow statuses? And it's important to let employees know that so they're not caught off guard or surprised. And it's also important to I think this is a big one, to set expectations around video conferences and when people are expected to be on video and when they're not, or if it's sort of make your own expectations. That's really important to be clear with employees. There's also, as I mentioned, wage and hour considerations for non-exempt employees, especially that are working remotely. And then also to make sure that any sort of hybrid work schedules that are subject to change are very clear, so the company can continue to meet business needs while also addressing performance issues, and making sure your expectations are consistent with the company culture that you're trying to embody, as well as other types of issues like making sure collaboration, there's an effective form of collaboration and other types of issues like that. And then if your policy is going to change, it's really important that you provide people with notice of that change and make that notice be clear and also very timely. I think that's a huge issue that we've seen in terms of not providing proper notice and the impact it has on employee satisfaction. Alrighty, so moving on to the next topic, there has also the final trend I'm going to be talking about before I turn it over to Renata to wrap it up, is this focus on employee health and wellness. I think a lot of employers, especially those we work with, have been recognizing the importance of prioritizing their employees' health, both mental and physical health and wellness. Not only for talent attraction and retention purposes, but also for the effect it has on enhancing work performance and productivity. So we're seeing a lot of new cutting-edge employee-friendly policies, and not just in big tech anymore. And some of the examples we're seeing are enhanced bereavement leave policies, including more time and more covered reasons, but also more covered individuals, including pets. We're seeing flexible time off policies, and I think this is sort of a topic of debate in terms of, how employee friendly that benefit actually is, but it is still a trend we're seeing. We're also seeing policies that are similar to parental leave policies, which is a huge employee benefit. Those have been around for a long time, but those are sort of morphing into more of a caregiver leave policy, which recognizes the fact that there are employees in all different stages of their lives, and this provides time off benefits for not only parents who are caregivers, but also people who may be caring for ailing or aging parents, for example. And I had a question here too, if you want to volunteer or just think about it, like what unique policies has your organization implemented, or are you considering? If you want to put that in the chat, if you care to share, or just think about it, and maybe it's a topic you bring back to your organization. And with that, I will turn it over to Renata to talk about our last trend before we wrap up.
Thank you, Meg. So I will discuss some developments with the National Labor Relations Board. As you all are likely aware, the National Labor Relations Act states that an employer is generally prohibited from maintaining and applying policies that interfere with the rights of employees to engage in union or other protected concerted activities. And one common misconception about the NLRA is that it only applies to unionized workers. In fact, the law applies to both union and non-union employees, so this can have an impact on the policies of all employers, regardless of whether or not you have a union present in your workforce. The key thing to remember about the National Labor Relations Board is that it swings like a pendulum based on the changes in the administration. So right now, the board is in a state of flux. President Biden promised during his campaign to be the most pro-labor president that we have ever seen, and he is living up to that promise. Jennifer Abruzzo was sworn in as the general counsel of the NLRB in July of 2022 and has issued a series of general counsel memos that provide a roadmap for numerous pro-labor initiatives. One of these being to revisit the current standard for determining the lawfulness of a handbook policy. So why is this important? Well, because the NLRA provides employees, even in non-union settings, with the right under Section 7 to engage in what's referred to as protected concerted activity, which can include a number of things such as talking with others about their wages, hours, and other working conditions, forming and joining a union, bringing group and other work-related complaints, making complaints on social media, and so on. The previous NLRB, or the Trump board, had issued a fairly pro-employer decision regarding the proper standard for evaluating policies that may or may not infringe on employees' Section 7 rights. Many decisions that came out found that certain handbook policies were lawful, but in those decisions, there was one lone Democrat, Lauren McFerrin, who issued scathing dissents that really provide a roadmap for how employers should, at least under this current Biden board, be drafting and applying their workplace policies. So we know based on McFerrin's dissent and the GC memo that they really want to return to the Obama standard, which is that the mere maintenance of the neutral work rule will violate the act if the employees would reasonably construe the rule to prohibit union and other protected concerted activity. So let's move on to the next slide to talk about some of these policies. This is a list of policies commonly found in employee handbooks that can be subject to scrutiny. It's not an all-exhaustive list. Starting out with confidentiality, these typically come up when an employer is investigating workplace misconduct and advises employees that the investigation is confidential and that they should not discuss it with others. McFerrin said that these types of policies require employees to suffer in silence at work. Email and other communication policies are a big one. While prior decisions really focused on email, the Biden board wants to expand that coverage to things like Zoom, text, Slack, and other communication standards. Third-party access, the Biden board would really like to change the current law and allow unions and other third parties access to employer premises. Recording policies, anytime you tell employees that they cannot record conversations at work, that can be risky. So the better practice would be for the manager or the HR person to simply say, I don't consent. And if you want to record, then we have to end the conversation. Social media is one that comes up a lot. You need to be very careful about restricting what employees might be able to post on social media. And so when you are drafting and reviewing your policies, just kind of keep in the back of your mind, does this policy or agreement restrict employees' access to the NLRB, prohibit them from discussions regarding their working conditions, wages, benefits, safety, that sort of thing? Does it prohibit employees from talking about internal investigations or from talking to the media or what they can post on social media or anything that could sort of chill their ability to engage in protected concerted activity? Any of those elements could be problematic. So I will pass back to Chelsea to take us across the finish line.
Thank you so much, Renata and Meg and Jean, for everything that you've been able to share with us today. I only have a couple of minutes left, so I'll go through this last section very, very quickly. But I did want to talk a little bit about how our handbook and policy team has been helping our employers over the last couple of years. And on the next slide, just who we are. We're a very big group of experts. We all are used internally as a resource to train, but also externally to help y'all with your handbooks and policies. We have built and updated our templates for every state's addenda, as well as as a national template, so that we've got these resources available to y'all. And we partner with our other teams within the organization, our paid sick leave team, our paid family leave team, to make sure that we're all working together to be or utilize all best practices. On the next slide, a little bit about what we've created. It's completely customizable. It's something that if you want to start from scratch, we can certainly do that, build it out for you, or we can use it as our resource in reviewing your book. It's not an off-the-shelf product. It's not something we can give away or sell because it's not designed to be a one-size-fits-all. It's not possible to do that. We think that's not best practices, and we certainly don't want to take you down that path. On the next slide, just a little bit about what we can do with y'all is obviously make sure that we're working with you to give the best practices that can be possible while increasing productivity, predictability, limiting cost, increasing efficiency. And so every time we work with a client to do this, we're already set up in a really good place to be able to help them the following year. Just a humble brag, I've had the pleasure of leading this team for the last couple of years, and I think that the people I work with are absolutely outstanding. And the number of handbooks that come in the door and go out to our clients is just a staggering number. And I'm so incredibly proud of the work that we've done. So I really hope that we've been helpful to y'all. We want to be helpful to y'all. I'm going to give you the CLE code because I know that you were waiting for it and I wanted to wait till 11:59 a.m. to do it. It is SS7873. And with that, I hope we've been able to address most of your questions. Our contact information is on the very last slide after you pass the CLE code, very important, SS7873. But if you go to the next slide, you'll see all of our emails. If any of you have any questions, I really do encourage you to reach out if you want help with your handbook, if you have questions on anything we addressed. This is how to reach all of us. But it's been my absolute pleasure. Love leading this team, love doing this webinar. Handbooks are one of my favorite things to do, as you might be able to tell. But we're here for you. So whatever you need, please let us know. So thank you and have a fabulous Thursday and a great Halloween and enjoy handbook season.